Let's talk about premises liability cases, sometimes called slip and fall cases. In order to have a valid premises liability case, you have to have three main elements. The first is that you have to be an invitee to the property. That means that you actually have permission to be on the property, that you're legally entitled to be there. For example, if you go shopping at a store, the business is inviting you into their premises, and so you're considered a business invitee, and if there's a problem there, you would potentially have a claim. So the first step is to make sure that you are there legally as an invitee. The second step is that there must be a dangerous condition that has a, quote, unreasonable risk of harm. So there's lots of conditions that could potentially be considered dangerous, but are not necessarily unreasonably risky. For example, a standard step or a standard set of stairs. Somebody could easily fall off a step and get injured, but as long as those stairs are constructed properly, they're not unreasonably dangerous. And so it would not be considered a dangerous condition for the purposes of a premises liability case. The third element is that the property owner must know about the dangerous condition, or at least have a reasonable opportunity to discover the dangerous condition. That means that that dangerous condition has to be there for enough time for the owner to discover it and try to fix it. For example, I remember a case that we worked on where our client was shopping at Safeway, and she slipped and fell in a puddle of water and was actually seriously injured. Well, we tried working on the case, and Safeway didn't want to settle it all because they had the video of the accident. They wouldn't share us the video of the accident, which was really annoying. But eventually we ended up filing a lawsuit and getting a copy of the video. And what that video showed is that literally like 60 seconds before our client fell, there was somebody else shopping at the store, and their kid was drinking out of a water bottle, and the kid spilled water on the ground, left, and then our client came by and slipped in that puddle of water. Well, even though that puddle of water was considered a dangerous condition, the store did not know about it. They didn't have enough time to discover that condition and mop it up. So those are the three things that you need for a valid premises liability case. You have to be an invitee, you have to be allowed to be at the store, there has to be an unreasonably dangerous condition, and there has to be enough time or notice to the owner of the store so that way they can have enough time to fix the condition.